Good morning, Mr. Chaskelson. Good morning, everybody.
Morning, Chair.
Good morning, Mr. Holden.
Good morning, Chair.
Thank you.
Chair, as we mentioned on Tuesday, today we will be following the flow of funds relating to the purchase of the Optimum coal mine. And we'll be doing that in great detail because of the particular symbolic importance of that transaction for this Commission. Obviously, everyone knows, Chair, that the purchase of the Optimum coal mine was the primary subject matter of the Public Protector's state capture report that gave rise to this Commission. The relevant diagrams that describe that flow of funds start in bundle 20 at page 321, Chair. And before we get to those, taking you through those diagrams, I just want to ask Mr. Holden to correct two errors on those diagrams which don't accurately reflect the narrative of his report which describes the flow of funds.
Yes. Yes.
Mr. Holden, can you take the chair to...
Before we do that, yesterday the registrar had to remind me that we didn't administer an oath to a witness, so at least today I must show that I remember. Please administer the oath again, or affirmation.
Please state your full names for the record. Please state your full names for the record.
Paul Edward Holden.
Do you have any objection to making the prescribed affirmation?
I do not.
Do you affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, I truly affirm.
I truly affirm.
Thank you, Mr. Holden. Mr. Chaskelson, we drawing to a close with regard to the oral evidence, so just in general for the Commission. So it feels good to be where we are in terms of we're about to finish the hearing of oral evidence, which started in August 2018. Yes, so thank you.
Mr. Holden, can I ask you just quickly to take the chair to the corrections that need to be made, and I understand they're on pages 321 and 332. And can you start with 321?
Certainly. Should I bring up the diagram on my screen? Would that be helpful?
Please do.
Yes, please.
And can you explain to the chair what needs to be changed on this diagram?
Certainly, Chair. I mischaracterized or mislabeled two of the payments and their routes. The first relates to the entry that is tagged 56,179,799 Rand, which flows from Transnet to Trillian Asset Management, which I'm going to bring up here. That forms part of what I call the Albertine stream. That amount didn't come from Transnet, it came from the Transnet Second Defined Benefit Fund. And that amount travels straight from, it doesn't travel straight to Trillian Asset Management, it rather goes to Regiment Securities from where it is distributed.
So, Mr. Holden, if I understand you correctly, that arrow, the problem can be corrected if the arrow that runs from Transnet to Regiment Securities is crossed out.
Correct.
And in its place, an arrow is taken from the box above Regiment Securities, which is the TSDBF.
Correct.
So the arrow that runs from Transnet to Regiment Securities should instead run from TSDBF to Regiment Securities. That's correct. And maybe if you, for everyone to see, if you could just trace the direction of where the arrow should run. I'm not sure if you could see my cursor. We can. You can. It should run down that way, from TSDBF Netbank down to Regiment Securities. Thank you. And then the second correction on this page. The second correction on this page is that I've effectively put the first swap fee where the club loan fee should be on this current diagram. So where it reads for December 2015, 56,179,799 Rand, that should actually read for December 2015, 93,400,000 Rand, and that's the club loan. And then can we go to page 331 where the same transactions are reflected in closer detail? Sorry, 332. Certainly, Chair. So to go through this one more time, first of all, I'll do the simplest change. The line running from Transnet. Sorry, Mr. Holden, can you just wait for a moment? The Chair's getting to... Absolutely.
I initially thought you said 322, so I discovered that it's 332, is that right?
That's correct, Chair.
Yeah, I'm there. Thank you. Yes, Mr. Holden.
So in the first instance, we have the Transnet box here and the arrow pointing downwards to Trillian Asset Management. That amount that I've accorded there, which is 56 million Rand, should be crossed out and replaced with the amount that flows to the left from Transnet. So that line from Transnet to Trillian Asset Management should read 93,400,000 Rand. In relation to the club loan.
Mr. Chaskalson, I'm not doing anything on my pages on the assumption that they will be replacement pages.
We'll have them provided by Monday morning, Chair.
Okay.
Mr. Holden, can you just briefly describe the second change that needs to be reflected on this page?
Certainly. The line that used to run from Transnet down to Trillian Asset Management, which is the first swap fee, it should instead run from a new box, or actually from a box that was on the first page of my diagram, which was TSDBF.
So there needs to be a new TSDBF box.
Down to the Regiment Securities.
Thank you, Mr. Holden.
In the amount of 56 million Rand.
Thank you, Mr. Holden, and we'll get replacement copies of those two pages produced by over the weekend. Finally, just for the record, Chair, I would like to confirm that the correct details of these transactions are in the main body of the report. And maybe, Chair, the references to note there are Bundle 9, page 438, 438, paragraphs 782 and 784.
Paragraph 7.
82.
82.
And 784.
Okay. Thank you.
Mr. Holden, before we get into the detail of the money flows, can you give the Chair an overview of the process that we are going to see illustrated by this flow of funds?
Certainly, Chair. I think we have a three-step process witnessed by witnessed in relation to this entire transaction. The first step is that the Gupta enterprise makes use of its access to the state to make an asset available, which is the Optimum Holdings asset. And the Commission has heard considerable evidence about how that was done to the benefit of the Gupta enterprise on the part of individuals like Mosebenzi Zwane, the Department of Mineral Resources, and Eskom as well. The Gupta enterprise, as the second step, then uses criminal funds that derives from state capture to raise the capital to purchase the asset that's just been freed, which is Optimum. And it uses this criminal funds as a form of bridging capital that the enterprise buy the resource at that time. And then finally, once Optimum has been
Mr.
bought,
Holden?
the Gupta enterprise.
Mr. Holden?
Yes.
There was a time when you broke. I think there was some technical glitch. We couldn't hear you. Do you want to just go back a little bit and then continue?
Certainly. I'll start from the beginning, if I may, Chair.
Yeah.
So the first step, that the Gupta enterprise uses the state to make an asset available to purchase. And the evidence the Commission has heard in relation to the role of Mosebenzi Zwane, the Department of Mineral Resources, and Eskom enforcing the Optimum sale is relatively well known. The second step is that the Gupta enterprise then uses criminal funds derived from state capture to raise capital to purchase the asset, that's Optimum, through a system that effectively sees criminal money from the state being used as a form of bridge finance advanced to the Gupta enterprise. Then the third step is that the Gupta enterprise then uses assets they've now bought using criminal funds, and that is used to pay the bridging finance that had been raised from criminal funds earlier. The effect is that the state ends up paying for over half of this asset and suffers a huge amount of collateral harm in doing so.
Thank you, Mr. Holden. Just briefly to recap some of the players here, can you remind us, first of all, who Griffin Line is?
Certainly, Chair. As I was discussing on Tuesday, Griffin Line is a company registered in Dubai, and it is under the effective control of the enterprise, as shown from the Gupta leaks.
And then can you remind us about the relationship between Griffin Line, Centaur Holdings, Centaur Ventures, and Centaur Mining?
The key entity for our discussions is Centaur Ventures. Centaur Ventures is 50% owned by Akash Garg. Akash Garg is short for Akash Jahaj Garia. And Akash Jahaj Garia is an in-law of the Guptas who was married to Vega Gupta in the infamous Sun City wedding. The other 50% is held by Centaur Holdings Limited, and Centaur Holdings Limited is fully controlled by two individuals, Simon Howe and Daniel McGowan. Centaur Ventures, which is based in Bermuda, held 100% share of Centaur Mining in Mauritius, and Centaur Mining in Mauritius had 100% shareholding in Centaur Mining South Africa. The effect of this is that Centaur Ventures owns 100% of Centaur Mining, which means that 50% of Centaur Mining is effectively owned and controlled by Akash Jahaj Garia or the Gupta enterprise, and the other 50% is controlled by Centaur Holdings Limited. The relationship between Griffin Line and Centaur Ventures and Centaur Holding is that the funds that are moved into South Africa to fund the purchase of the Optimum mine are sourced from a loan given by Griffin Line to Centaur Ventures in Bermuda. The loan is valued at $100 million. And on that basis, Centaur Ventures then seeks and receives Reserve Bank approval to extend a 1.5 billion rand loan to Centaur Mining in South Africa. Effectively, what you have, and I'll show this more clearly on the visualization, is Centaur, the entire stream of funds running from that is used by Centaur to purchase Optimum actually derives from Griffin Line, and Griffin Line is a criminal enterprise controlled by the Guptas.
Mr. Chaskelson, I'm not sure where he was reading from now.
He wasn't.
Oh, he wasn't. Oh, okay. Okay.
When we get to specific parts of the report, and
let me know. Yeah.
I will let you know, Chair.
Okay, all right.
Mr. Holden, maybe if we can now go to the first overview of this whole process, which is the diagram on page 321 of Bundle 20, and I see you have it up here. As we go further through these diagrams, you're going to speak of 4 different streams. The streams that you speak of are the Centaur stream, the Trillian stream, the Albertine stream, and the Eskom stream. Can you just mark on this overview diagram where the Centaur stream, what is the Centaur stream?
Certainly, Chair. What we have on the far left of the diagram, running from the first entry at the top, which is Griffin Line Trading, it then moves downwards.
I'm sorry, did you say 320?
321, Chair.
321.
And Chair, can I just check? I understood that there would be A3 pages made available for you today. I just want to check that you have a large diagram.
I've got 321. I'm not sure whether that's large enough.
It is. It's as large as we can do.
Okay, all right. Okay, now I can see, because I was comparing with what I see on the screen. Now I can see, yeah, I am at 321.
And Mr. Holden, if you can just identify for the Chair what the Centaur stream is, what you will later describe as the Centaur stream.
Certainly, Chair. So this is the full overview that you'll be seeing in front of you. The far left column, as it were, and I'll zoom in on it so you can see it, is starting at Griffin Line Trading and then running all the way down until it reaches Tegeta Exploration and Resources and Optimum Coal. That's what I consider the Centaur stream. And
can you give the Chair the references in the main body of the report where what you've described, what you've depicted in this diagram is described in a narrative?
Certainly, Chair. In relation to the Centaur stream, the reference is Flow of Funds 9, page 445, paragraphs 797.
1 second. Bundle 9, page 45.
445.
445. Paragraphs
797.
Yes.
To Flow of Funds 9.
Yes.
Page 458.
I'm sorry.
Paragraph.
I'm sorry. In terms of paragraphs, it's paragraph 797 to what?
To
paragraph?
840.
To 840.
Yes.
Okay. Right. Okay. I've got
it. Then can you zoom out onto the whole diagram and describe what you're going to refer to as the Trillian stream?
Certainly, Chair. I'm just getting slightly in. So the Trillian stream is the middle column, as it were, that runs starting at TSDBF, this entry over here, and then moving downwards. And as you can see, as it moves downwards, it enters into various Trillian accounts until it reaches Tegeta Exploration and Resources.
And can you give the Chair the main report references for the Trillian stream?
Certainly, Chair. That's Flow of Funds 9, page 440.
Yes.
paragraph 787.
Uh, 887.
787, Chair.
Oh, 787. Yes.
And that runs to Flow Funds 9, 445.
Yes.
And concludes with table 259, which sets out all of those transactions.
That's table 259,
59, Chair.
259. Yes. Okay.
And then can we do the same for the Albertine stream? Can you identify the Albertine stream on the overall diagram?
Certainly, I'm going to zoom out again so you can see it in relation to everything else. The Albertine stream is this third column proceeding downwards. And I'll zoom in on it. It starts with this Transnet box here, which will obviously need to be corrected, and I'll supply that shortly, and then runs down via regiments and into Albertine, and then into to get exploration and resources. What is added on to the Albertine stream, which I'll explain in more depth, is that the Albertine stream then moves to all of this information on the right-hand side, which runs to the right of Albertine's Bank of Baroda current account entry. And it's quite a complicated laundry here. The reason that's included is because the Albertine funds, once they are liberated as bridging finance, then get pushed through the local laundromat that I described on Tuesday, and some of which ends up paying out back to Griffin Line Trading. And obviously I'll go through that in quite a lot of depth.
And again, the report references for the Albertine stream.
For the Albertine stream, it's Flow of Funds 9, page 438, paragraph 781.
I'm sorry. It's bundle 9, flow funds, page
438.
438. Yes.
Paragraph 781.
Yes.
To Flow of Funds 9.
Yes.
Page 440.
Yes.
And that concludes with table 258.
258. Okay.
And the last stream that you describe is the ESCOM stream. Can you just show where that appears on the overall diagram?
Certainly, Chair. The ESCOM stream is at the very bottom of the diagram, and starts with this green box over here, which I'll zoom into. And this is the ESCOM stream here. And I trace all the funds flowing from ESCOM to get to resources, Quinfantine coal mine, and to Optimum Coal.
And again, the reference in the main report
is Flow Funds 9, page 437.
Yes.
Paragraph 780.
Yes.
Chair, as I'm being given an opportunity to correct that error, what I might do is when I deal with each individual stream, I will put on the review diagram the references as well. So they'll be available on the diagram for everyone to cross-reference.
Okay, all right. Did you complete your reference to the main report in regard to the ESCOM stream? I've got bundle 9, page 437, paragraph 780.
That's correct, Chair.
Okay, all right.
Now, Mr. Holden, we know that the total amounts that was paid to Worksmans to facilitate the purchase of Optimum on the 14th of April 2016 was 2,084,210,206 rands and 10 cents. Can you tell the Chair what amount of that 2 billion odd you calculate to have been derived from criminal funds in a way that you're going to describe when we go through these diagrams?
Certainly, Chair. The figure that I arrive at is 1,826,942,861 rand and 16 cents. And for the transcriber, that is 1,826,942,861.16.
And again, can you give the Chair a reference in your report where you deal with that figure and its calculation?
Certainly, we have, it's at Flow of Funds 9, page 435. Paragraph 778.
778.
That's correct.
Okay.
And ending with the table that appears at the end of paragraph 779.
Yes.
And what proportion of this purchase price is paid by Eskom?
Certainly, Chair. I think up until we conducted this analysis, our original sense was that the amount that Eskom had paid was lower than what I discovered. My calculations show that Eskom eventually and ultimately contributes 1,046,522,865 rand and 79 cents. Again, for the transcriber, that's 1,046,522,865.79. And this could be split into two amounts. The first amount is paid to Together prior to the purchase of Optimum, and quite a lot of evidence has been heard in relation to that. And that total amount is 728,211,861 rand and 16 cents. So that's 728,211,861.16. Subsequent to the purchase of Optimum, Eskom makes payments that are then used to repay this bridging finance to a total of 311,004 rand and 63 cents. So that's 318,311,004.63. The result of which is that Eskom effectively pays for more than half of this 2 billion rand asset for the Guptas.
Can I then ask you to start with the Centaur stream, which is at page 322. And can we go slowly through the Centaur stream? You've identified where it sits on the big diagram. Now we're going to go slowly through it. And maybe before you take the Chair through the Centaur stream, can you explain what the particular significance of what you're about to say in relation to the Centaur stream is in relation to asset recovery from the Guptas?
Certainly, Chair. As I'm sure the Commission is well aware, Optimum remains the Gupta Enterprises' largest and most significant asset in the country, and that is being, the disposition of that asset is being fought through the courts and through business rescue. What I will show is that the Centaur component of that asset, and Centaur is now laying a claim of a significant amount of money against that asset, actually derives from criminal funds, on which basis, and that application, I should add, is frustrating attempts by Eskom to recover its own losses in relation to Optimum. I believe that the evidence that I'll be showing now would give grounds for the asset forfeiture unit to consider proceeding with an asset seizure in relation to this, and that may allow this asset to be returned to Eskom, either to settle its loans or be returned to the state. It would effectively mean that the last asset that the Gupta Enterprise is trying desperately to remove from South Africa would be rightfully returned to the government.
Now, you're just talking about assets. I think we need to explain the scale of what we're talking about. Can I ask you to go to bundle 16, page 28, which is the Bermuda judgment? And can you read a little paragraph, Roman 1, from that judgment on page 28?
Certainly. A paragraph, Roman numeral 1, it says, on 19 February 2018, OCM, that's Optimum Coal Mines, became distressed and entered into a process of business rescue. CVL, which is Centaur Ventures Limited, had previously entered into coal trading contracts with Optimum Coal Mines, OCM, and was owed approximately $74.5 million by OCM.
That's $74.5 million, which is the claim that Centaur is asserting against Optimum Coal. What does that translate into rands?
Putting me on the spot here slightly, it would be equal at the current exchange rate to approximately 1.4 billion.
I think you may be overstating it, but it's certainly more than $1 billion.
I need to check what the exchange rate is at the moment, but if it's a 10 rand, then it should be 745 million rand.
I'll stay with a bit more than $1 billion. We'll get today's exchange rate and work out what 74.5 million is. But we're talking about a very, very substantial claim. To your knowledge, is there any other Gupta Enterprise asset approximating this claim remaining in the country?
No, Chair.
Right. So then let's go and look at what you call the Centaur stream against the background of this context, that it's linked to the last remaining asset of note of the Gupta Enterprise in the country, an asset worth more than R1 billion. Can you take the chair through page 322 and the series of diagrams that follow?
Certainly, Chair. I trust the diagram is on the screen. The Centaur Venture stream, the step 1 of the entire process, begins with Griffin Line Trading right at the top here, which gives a $100 million loan to Centaur Ventures, which is then made available to Centaur Ventures Bermuda. Against that has just been loaned, Centaur Mining in South Africa then takes out a 1.5 billion rand loan against that $100 million. And that loan, a portion of that loan, and I should add that close to the full amount of the loan is eventually withdrawn and drawn down, but that funds other streams, so I won't focus on that now. But in relation to this particular purchase, between the 26th of February 2016 and the 1st of April 2016, let me try to zoom in so people can see that a bit better, 885,449,000 is drawn down from the Centaur Mining loan facility and paid into Centaur Mining's Standard Bank account 226708666. So in very bold summary, we effectively have a loan from Griffin Line Trading being drawn down through various intermediary loans into Centaur Mining Standard Bank account. We then proceed to the following page. The second step is that once the amount has been drawn down and paid into Centaur Mining's Standard Bank account, Centaur Mining then transfers an amount of 885,300,000 rand between the 9th of March 2016 and the 4th of April 2016, and pays that in its Baroda current account. I don't reflect the current account number here, but it is in the report, and I'm sure we can get that in the tea break.
Mr. Holden, we had technical glitches again. Maybe just step back, and start about 4 sentences that you had already done, and then continue.
Certainly. So should I proceed to the beginning of this step?
Okay, yeah, we didn't hear some sentences.
Apologies, Chair. To begin again, once the loan has been drawn down from Centaur Mining and paid into Centaur Mining Standard Bank account, it immediately then transfers of that amount 885,300,000 between the 9th of March 2016 and the 4th of April 2016 into Centaur Mining's Bank of Baroda current account. Once those amounts have been received in Centaur Mining's Bank of Baroda current account on the 12th of April 2016, it then transfers and it opens a new fixed deposit account with the Bank of Baroda, which is 03/641, and it pays an amount of 886,559,781 rand. This amount is made up of the capital amount that was transferred to Centaur Mining, Centaur Mining's Bank of Baroda current account, and the interest that it accrued on that capital amount. And then flowing down here, on the 14th of April 2016, the Bank of Baroda issues a loan facility for Tegeta Resources and Exploration. That loan facility is 06/467, and that is secured against the Centaur Mining fixed deposit account 03641. The relevance here, I think the importance here is that you effectively have, through these various back-to-back loans, you've moved $100 million from Griffin Line, which is a Gupta Enterprise entity, into a loan facility controlled by Tegeta Exploration and Resources.
Can I just clarify what you're saying before you presented that last overview? That the fixed deposit of Centaur Mining, the 842 million fixed deposit of Centaur Mining, was used to secure a loan not to Centaur but to Tegeta.
That's correct, Chair.
Was any security provided to Tegeta for that loan? Sorry, it was provided to Centaur for that loan?
No, Chair.
And can I take you to bundle 16, page 48, to see who, on behalf of Centaur, decided that they would put up 842 million to facilitate a loan to Tegeta? Bundle 16, page 48.
Certainly. I'm afraid I don't have a stream from the hearing venue. I think it's been a video stream. I think it's been turned off to improve bandwidth. So it'd be good to get an indication once the chair has reached that point.
Yes, I am on page 48.
And the chair is there. It's Annexure 106. Can you describe to the chair what Annexure 106 is?
Certainly, Chair. This is an excerpt from the minutes of a meeting of the Board of Directors of Centaur Mining South Africa, which is held via telephone conference initiated from Dubai on the 12th of April 2016. The resolution is that the company, which is Centaur Mining, allow Tegeta Exploration and Resources Limited to avail a loan of 842,231,000 against the deposit of the company for 886,559,781, and Mr. Akash Garg, in his capacity as the authorized signatory of the company, be and is hereby authorized to sign all documents in this regard. So the short answer, Chair, is that this loan to Tegeta from Centaur, this unsecured loan, is signed off by Akash Garg, an in-law of the Guptas.
And maybe if you can also just read that last sentence as well before we see certified a true copy.
That the company pledged the deposit as security to the Bank of Baroda for the duration of this facility.
So can you just explain what that means?
Certainly. That as long as this loan is outstanding, the Tegeta Exploration and Resources loan is outstanding, Centaur Mining won't close its fixed deposit account containing this amount. So that if Tegeta was to default on the loan, the Bank of Baroda would be able to seek compensation from this fixed deposit account held by Centaur Mining.
Thank you, Mr. Holden. Can you then go back to the diagrams at page 324?
Me, Chair. So once the Tegeta Exploration and Resources loan has been funded in this way, I move to the following page. And on the 14th of April 2016, Tegeta Exploration and Resources draws down.
I'm sorry, are we back at 323?
324, Chair.
324. Okay, I'm there.
Thank you, Chair. So once that loan has been extended, Exploration and Resources on that full loan amount, and 842,231,000 rand is then transferred into Tegeta Exploration and Resources Bank of Baroda current account, which is 02/042, and that's done on the 14th of April 2016. That amount then commingles with the other streams, which I'll deal with shortly, to then fund the total payments to Bachmans on the 14th of April 2016 of 2,084,210,207. If I may, I think what is very noticeable about this tranche is that you effectively have 3 back-to-back loans that are opened against each other effectively in order to move funds to get an exploration and resources to pay out. All of those ultimately originate, and clearly this has been designed in part to disguise Griffin Line Trading's involvement in this particular transaction.
Sorry, Mr. Holden. Is Mr. Holden out of the country or far away from Gauteng? I think these technical glitches are frustrating me.
I'm afraid
the type of evidence he's giving is very important, and when one reads the transcript, one shouldn't have too many inaudibles because otherwise you won't follow. So I'm very concerned about to what extent with these technical glitches where we don't hear some sentences, we might end up with that, and that would be quite frustrating.
Chair, I'm afraid he's a long way out of the country. He's in London.
Okay.
Maybe if we could take a tea adjournment now, I think,
yes.
I think that the problem lies in our internet connection in this building.
Yes,
and maybe if we could try to resolve that at a tea adjournment.
Yes. No, that's fine. We can do that. It's just that the evidence is such that when one reads it in the transcript, I think one should not lose anything. Otherwise, you misunderstand the journey of the funds and how it came about. So,
indeed, Chair.
yes. Okay, let's take the adjournment now. Then we adjourn.
Mr. Holden?
Yes, I'm here.
All right. Oh, thank you, sir. We are about to start again.
Great, thank you.
Okay, thank you.
Okay, let's continue. Hopefully, there will be less technical glitches.
Thank you, Chair. Mr. Holden, you've taken us through the process by which 842 million is made available or finds its way into the worksman's account to purchase the Optimum coal mine through a series of back-to-back loans. Before we finish on the Centaur stream, is there anything further that you want to say before we move over to the Trillian stream and track the flow of the money into the worksman's account via Trillian?
Yes, thank you, Chair. The one thing I'd like to add is, and to remind the Chair, is that the Centaur loan, apologies, the Griffin Line trading loan to Centaur Ventures, as I discussed on Tuesday, is also an unsecured loan. So you have a series of unsecured loans for this vast amount of money, eventually being used to purchase Optimum.
Right. Your diagrams that on the succeeding pages actually track what happens to the fixed deposits later on. Before we get there, I think I would like us to follow the flow of all of the money into the worksman's account and then come back, time permitting, to see what happens to the funds, to the fixed deposits after the mine has been paid for. So let's then move to the Trillian stream, which is your diagram on page 329. And can you take the Chair through that diagram? But maybe before we get into the flow of funds, it's important to deal with the source of these funds, which on your diagram is the Transnet Second Defined Benefit Fund. Can you just talk through some of the implications of the fact that it's the Transnet Second Defined Benefit Fund that is the source of this stream?
Certainly, Chair. this stream, I mean, all the streams are outrageous. This is particularly egregious because this is effectively stealing money from a fund that funds pensions on which a lot of people rely. The average annual pension paid by the fund is 32,198 Rand, which equates to 2,683 Rand per month. Most of the fund's beneficiaries of these payments rely entirely on this payment to survive. The theft of funds from TSDBF to fund this purchase is effectively stealing money from some of the most hard up and needy people in the country.
Can you just give the Chair the reference to those figures that you've just quoted? An average monthly pension of 2,683 Rands and 17 cents per month.
Certainly, Chair. The reference there is, it's at Annexure 12, and that's Flow of Funds 9, page 654.
Yes, I've got that.
Paragraph 4.
Mm-hmm. Okay.
And that document is the affidavit of Mr. Maritz, who is the principal officer of that pension fund. Mr. Holden, can you then take us through the flow of funds in relation to the Trillian stream?
Certainly. The stream begins with TSDBS Nedbank account, which at this stage, as I'm sure that the Chair has heard lots of evidence on already, that account is effectively under the control of regiments. It transfers the second, third, and fourth swap fees arising from its interest rate swap transactions into Regiment Securities Nedbank account. Between the 8th of March and 2016 and the 11th of April 2016, 171,264,215 Rand is paid to Regiment Securities through this route. And you can see, if my cursor is showing up on screen, I'm now circling those three. I'll zoom in slightly closer. These are the three streams that make up the amount of 171 million Rand stolen from the TSDBF. Once that amount reaches the Regiment Securities account, it is then transferred to Trillian Financial Advisory's Absa Bank account. And using the funds that's just been paid, Regiments transfers 169,525,161 Rand and 30 cents is transferred to Trillian Financial Advisory's Absa account between the 11th of March 2016 and the 14th of April 2016. Following step, all of those funds, or a substantial portion of those funds, are transferred to Trillian Management Consulting's Bank of Baroda account, and their Baroda current account was 02/512. In total, the amount transferred to TMC arising from these funds is 160,679,269 Rand. As you can see here, three of the payments went straight from Trillian Financial Advisory's Absa account into Trillian Management Consulting. There was one payment, however, that passed through two additional Trillian accounts before reaching Trillian Management Consulting. But I think the primary takeaway here is that all of these funds paid into Trillian Management Consulting's Bank of Baroda account here are effectively stolen from the TSDBF.
And then what happens to all of the money that lands in the Baroda account?
Certainly, Chair. The next step is that once the amount has been paid into Trillian Management Consulting's account, on the 14th of April 2016, and that is also the day of the purchase of Optimum, Trillian Management Consulting uses those funds to open up a Bank of Baroda fixed deposit account, and it transfers a total amount of 160,246,000 into the new Baroda fixed deposit account. That Baroda fixed deposit account is 03/643. On that same day, Tegeta Exploration and Resources then takes out a new Bank of Baroda loan, and that loan is 06/468. That amount is taken out against the Trillian Management Consulting's fixed deposit account, as you can see here. That's where there's a line going down. And on the 14th of April, same day the fixed deposit account is created, an amount of 152 million rand is drawn down from that Tegeta Exploration and Resources Bank of Baroda loan and paid into Tegeta Exploration and Resources Bank of Baroda current account 02/042, where it commingles with the other streams to then fund the payment of over 2 billion rand to Wackmans.
So, can I just clarify? We have another case of money flowing through various entities ostensibly belonging to third parties, ending up in a third-party deposit at the Bank of Baroda, against which Tegeta is allowed to borrow money from the Bank of Baroda using that third-party deposit as security. Is that correct?
That's correct. That's an excellent summary, Chair.
And have you been able to find any security that any of the Trillian companies demanded for putting up a fixed deposit, or for pledging a fixed deposit of 160 million as security for a loan from the Bank of Baroda to Tegeta?
No, Chair, I have not.
And maybe we should go to Annexure 101, which is the Trillian resolution to facilitate this transaction, to see who was responsible for it. Can I ask you to go to bundle 15, page 719?
I am there, and I've also put up the annexure on screen as well.
And can you take the chair through this annexure?
Certainly. This is, as you can see from the letterhead, this is an excerpt from the minutes of a meeting of the board of the directors of Trillian Management Consulting, Pty Limited, the company, held at Sandhurst on the 13th of April, 2016. I'll read the resolution. That the company allows Messrs. Tegeta Exploration and Resources Pty Limited to avail a loan of 152 million rand against the deposit of the company, that's Trillian Management Consulting, for 160,240,000 rand, and Mr. Mark Chipkin, in his capacity as the authorized signatory of the company, be and is hereby authorized to sign all the documents in this regard, that the company pledge the deposit as security to the Bank of Baroda for the duration of the facility. And that is then certified, a true copy, and signed by Eric Anthony Wood on the 14th of April, 2016.
Now, I'm not sure if you can put up that resolution and the central resolution on your screen simultaneously. Are you able to do that relatively simply? If not, then we don't need to do that. We can just achieve the same result by me asking you a question. Can you put the two up simultaneously?
I will do my best. I guarantee nothing.
If I give you the reference for the Centaur resolution is in volume 16, page 48. I think let's just ask the question. It may be clear.
Yeah, I'm afraid I have them both loaded up in my computer, but I don't quite know how to show them side by side using Acrobat.
Is there anything that strikes you about those two resolutions?
The wording is exactly the same.
Exactly, yes. Let's get to the third component of this process, which is the Albertine stream. And that you deal with at page 332. And maybe to begin with, if you can just refresh our memory on the two changes that need to be made to this diagram.
Certainly, Chair. The two changes are that easiest change first is that the amount flowing from Transnet down to Trillian Asset Management Investec, which I have labeled first swap fee, that amount needs to be deleted from this visualization and be replaced with the amount over here, which is for December 2015, which of 93,400,000 Rand for the club loan. So what we have is the club loan entering into Trillian Asset Management Investec account. And what we should additionally have is a box over here above Regiment Securities, which appears in the overall diagram, which is CBF. And the entry that I did have running from Transnet down to Trillian Asset Management that has now been deleted should then be put into that, flowing from that amount into Regiment Securities. And that amount is 56,179,799 Rand, and also dated the 4th of December 2015. With that concluded, what effectively happens is that those two amounts that are paid up from the two different sources, the amount that is paid in relation to the club loan is paid to Regiment Securities Nedbank account, and from there it is then transferred on the 7th of December 2015, an amount of 50 million Rand is transferred into Regiment Capital's Standard Bank account.
Sorry, Mr. Holden, I have to correct you on that front. With your corrections, the amount that goes into Regiment Securities is not the club loan amount, it's the first swap fee.
Yes, apologies, yes, sorry, Chair, it's the first swap fee of 56 million. And out of that 56 million swap fee, the 50 million is then transferred from Regiment Securities to Regiment's Capital's Standard Bank account. And then returning to the above, the club loan is paid into the club loan amount of 93 million is transferred into Trillian's Asset Management Investec account. And on the 9th of December, of that amount of 90 million Rand odd, 74,784,000 is then transferred from Trillian Asset Management's Investec account into Albertine's Bank of Baroda current account, and that's their account number with the Bank of Baroda is 02/452. 2 days later, the amount that emanated from the first swap fee, the TSDBF fee, and in effect from some of the country's most needy pensioners, is paid from Regiment's Capital. Of that amount, 42 million Rand is paid into Albertine's Bank of Baroda current account on the 11th and 12th of December 2015. The essence of what I've just described is effectively money moving from TSDBF and from Transnet and being placed into Albert Times Bank of Baroda current account. Again, on the 14th of April, which is the day of the purchase, Albert Time transfers 110 million rand from its Bank of Baroda current account 02452 into a newly created Albert Time fixed deposit account. I think you can see a pattern here. And that Bank of Baroda account is 03/644. On the same day, Albert Time, to get to exploration and resources, takes out a Bank of Baroda loan, 06469, issued against the Albert Time fixed deposit account. And again on the same day, over to the left here, the to get to exploration and resources loan is drawn down so that the full amount of 104,500,000 rand is paid into to get to exploration and resources Bank of Baroda account 02/042, where it commingles with the other streams I've already identified and the ESCOM stream I'll deal with next, to then fund the payment of 2,084,210,206 rand and 10 cents to Ackmans to fund the purchase of Optimum.
And can I then ask you to go to bundle 15, page 707, to see the Albert Time resolution for this pledging of 110 million to secure a loan made from Baroda to Tegeta?
Certainly, I'm there. I'm waiting to hear that the chair is ready.
Yes, I'm there. Thank you.
What this annexure shows, Chair, is an extract from the minutes of the meeting of the Board of the Directors of Albert Time Proprietary Limited, the company held at Johannesburg on this 14th day of April 2016. And I'll read the resolution. That the company allows Tegeta to avails, and I'm assuming they mean avail, a loan of 104,500,000 rand from Bank of Baroda against the term deposit of 110 million rand, and Mr. Kubunturan Mudli, in his capacity as the director of the company, be and is hereby authorized to do all the necessary documents / formalities required in this regard. The said term deposit serving as security to the bank for the duration of this facility. That is then signed, certified a true copy by Mr. Kubunturan.
Then can we move to the ESCOM stream, which is addressed at page 337.
Certainly, Chair.
I'm sorry.
I'm now at that
I'm sorry, Mr.
page. I'm not
Chaskalson.
sure if the chair is as well.
I was, you drew my attention earlier on, you and Mr. Holden, to the identity of the wording in those two resolutions. And I was now looking at 707 and 706. on paper.
It's very close, but it's not identical in the way that the other two are.
Yes, yeah. Okay, to what page should we go now?
337, Chair.
On the same bundle?
Say, bundle 20, yes.
Bundle 20.
Oh, sorry, bundle 20, yes.
Okay. $337 on bundle 20.
Indeed, Chair.
Okay, I'm there. Okay.
All right, Chair. I've zoomed out slightly so you can see the full stream, but the essence of the stream is very simple. Apologies, I've gone to the next page. From Eskom, a different place in the diagram, on the 13th of April 2016, Eskom transfers two amounts to get Exploration and Resources FMB account 6211-735-6990. Those two amounts are 659,558,079 rand and 38 cents, and then a second amount of 68,653,781 rand and 78 cents. On the same day, the Get Exploration and Resources transfers two amounts to its Bank of Baroda current account, 02/042. The two amounts that are transferred are 660 million on the 13th of April 2016, and a second amount of 68 million on the 13th of April 2016. And the following day, once it is commingled with all the other funds that have come in from the other streams, it then funds the purchase of the purchase payment to Vaxmans on the 14th of April 2016 of 2,084,210,206 rand and 10 cents.
Just to remind me, Mr. Holden, on these diagrams, when we started on your first day of dealing with them, green was where the money originates from and red is where it ends up. Is that correct?
That's correct, Chair. The green is for go and red is for stop.
Yeah, okay.
Now, a couple of questions in relation to this Eskom stream. We've heard evidence that the 659 million that was paid was the prepayment for coal from Optimum. Where does that 659 million get paid by Eskom? Does it get paid to Optimum or to Tegeta?
It gets paid to Tegeta, Chair.
We've also, I think, heard evidence in an attempt to defend the rationality of that prepayment. I think Mr. Koko has given that evidence in the commission as good value for money. And more generally, when we deal with the proceeds of the fixed deposits and the repayment of the loans and the freeing up of the fixed deposits with Eskom funds, an argument could be put that, well, Eskom is paying for coal from Optimum and Eskom is receiving coal from Optimum, so what is the problem with Eskom making these payments? Do you have any answer to that argument?
Certainly, Chair. As the Chair may be aware, Eskom is now seeking considerable damages in relation to these transactions. Eskom has indicated that it suffered huge losses on these contracts, partially because it didn't receive the required quantities of coal on time, and partially because the quality of coal was of a poorer quality than had been contracted for. Eskom did not pursue those original claims, those penalty claims against Optimum. And I'm sure we'll turn to it shortly. The application for compensation, the SIU application, indicates that Eskom had to spend a pretty vast amount of money to cover itself because of those failures of the Optimum coal deliveries.
Well, maybe we should go to that SIU summons. it's in bundle 20 at page 361. Chair, can we give it an annexure number because it hasn't been introduced as an annexure? I think we're on I.
I don't recall at all where we are with the numbering. But you said 361.
It's page 361. Can we provisionally number it VV10 10I?
V for Valentine.
Indeed.
And then B for Beatrice.
No, VV, double
VV.
Valentine.
Yeah, okay. Yeah, VV.
Ms. Masilo tells me it should be VV10J. We already have an I.
Oh, okay. And this is the summons.
It's the summons issued by Eskom and the SIU against various former Eskom executives and various members of the Gupta family and Salim Essa.
Yes, the summons in the High Court of South Africa, Gauteng Division, Pretoria, case number 35689/20, in the matter between Eskom Holdings Stock Limited and Special Investigating Unit, first and second plaintiff respectively, and Brian Mulefe and others, is admitted as Exhibit VV10J.
Can I ask you to take the chair to page 403, paragraph 96?
I'm there.
And Mr. Holden, are you, can you take us through the first component of the Eskom claim, which relates to historical penalties? That's paragraphs 96 to 101.
Certainly. Paragraph 96, it reads, on or around 13 March 2017, Daniels, who was an Eskom employee, submitted a memorandum recommending that the outstanding penalties on the Hendrina CSA in respect of the period 2012 to 2015, I should emphasize that CSA is the coal supply agreement, which had been claimed from OCM, Optimum Coal Mines, under Glencore control in the amount of 2,176,530,611 rand and 99 cents, be settled for an amount of 577 million rand. Paragraph 97, it reads, Singh endorsed Daniel's recommendation on 14 March 2017, and COCO approved the recommendation on 14 March 2017. At paragraph 98, on 16 March 2017, Eskom's dispute with OCM and Tegeta over the outstanding penalties was settled for an amount of 577,839,105 rand and 42 cents, and the settlement was made an award by the arbitrator in the dispute between Eskom and OCM and Tegeta Advocate Solomon SC. At paragraph 99, at the time of the settlement of the penalty claims, Daniels, Singh and COCO knew that Eskom's actual justified penalty claim was 1,166,164,713 rand and 37 cents, but deliberately settled the lower amount of 577 million rand, 839,105 rand and 42 cents to further the interests of Tegeta in accordance with the conspiracy. As appears from Annexure 11, when regard has had to penalties already deducted by Eskom from payments to OCM, the balance due by OCM and Tegeta was 255,400,819 rand and 18 cents. OCM and Tegeta have failed to pay Eskom an amount of 133,781 rand, 781,381 rand and 48 cents, and therefore at paragraph 101, The total penalty-related loss caused to Eskom by the conspiracy accordingly comprises 722 million rand, 106,989 rand and 43 cents, and then it sets out the calculation just described above.
So Eskom, in relation to unpaid historical penalties, is alleging that it has lost 722 million on this optimum deal. Can we then go to the next paragraph, 102 and 103, which deal with a separate head of damage claimed by Eskom in relation to poor quantity and quality of coal that was delivered while Optimum was under Tegeta control?
Certainly, Chair. Paragraph 102, it reads, over the period September 2016 to 31 December 2018, being the termination date of the Hendrina coal supply agreement, OCM, whilst under the control of Tegeta, consistently refused, alternatively was unable, alternatively failed to meet the coal delivery quantity and quality obligations specified in the Hendrina coal supply agreement at that time that Tegeta purchased OCM. And then on the following page, paragraph 103, as a result of OCM's refusal, alternatively inability, alternatively failure to deliver coal, the quantity of coal specified in the Hendrina coal supply agreement at the time of Tegeta's purchase of OCH, Eskom had to incur additional costs in the aggregate amount of 2,441,161,443 rand to procure coal from sources other than OCH for the Hendrina power station. And that is set out in a spreadsheet attached as Annex 12 to the SIU summons.
And so that's quantity. Going to quality in paragraph 104.
As a result of OCM's refusal, alternatively inability, alternatively failure to deliver the quality of coal specified in the Hendrina coal supply agreement at the time of the Tegeta purchase of OCH, Eskom suffered losses in the aggregate amount of 89,335,464 rand and 7 cents, being the aggregate amount of penalties that Eskom did not deduct from purchase payments to Tegeta, but would have fallen due to Eskom under the terms of the Hendrina CSA as of the date of the Tegeta purchase, such penalties being an accurate proxy for the cost to Eskom of receiving coal below the contractually specified standard. And again, there is a spreadsheet that is attached as Annex 13 to set out those values.
So this isn't evidence, but what it is it's a statement of a claim that essentially says that in relation to the coal that was supplied, Eskom, and in relation to the historical penalties that weren't recovered from Optimum once it passed to Tegeta's control, Eskom has suffered losses of over 3 billion.
That is correct, Chair.
I do want to emphasize not evidence, it's what Eskom is claiming. Having said, can we at this point go back to see what happened to the fixed deposits that were used to free up the loan finance for the purchase? We tracked all of the money into the fixed deposits and seen how they were deployed by Centaur, Albertime, and Trillian to free up amounts which ultimately were more than R1 billion that were lent by Baroda to Tegeta to facilitate the Optimum purchase. Can you give the Chair an overview of what happened to those fixed deposits after Optimum was purchased? I'm just conscious of time, and I would like us to get to some of the recommendations that are addressed in the report that was submitted as an annexure. I forget the annexure number. I do want us to be able to have some time to address those before 1 o'clock, which is when your evidence will end. So with that in mind, I think the overview may have to be relatively high level as opposed to detailed, we can cross-refer to the references in the report where the detail is to be found.
Certainly, Chair. At a very high level, all of those fixed deposit accounts subsequent to the purchase of Optimum are closed, and the proceeds paid back into the original current accounts that funded those fixed deposit accounts. So, for example, with Centaur, we can see very briefly here on the 6th of April 2017.
So, sorry, if you can just give the Chair, are you at page 325?
I have to admit that I'm using a different...
Sorry, Mr. Holden, we've got a technical problem on this side. It is working, yes. Thank you, Chair. No, my microphone is working. Chair, can you?
Oh, okay, it's back. Okay. Okay, no, thank you. I wanted to double check now what page that is, because I think I missed that Mr. Holden was speaking on.
325, Chair, 325 of Bundle 20.
Okay, all right. Thank you. You may continue. 325 or 335?
325.
325. Okay. Okay, you may continue.
Certainly, Chair. Again, to reiterate, at a very high level, all of those fixed deposit accounts are closed and the proceeds paid back into the original current accounts from which they were paid. In the example of Centaur, we see, for example, that on the 6th of April 2017, an amount of 886,559,781 Rand is transferred into Centaur Mining's Bank of Baroda current account, and that's because of the closure of the that fixed deposit. There is a very important point to raise here, which is that at this stage, to get a loan that had been issued and which Centaur had pledged security to Bank of Baroda of 842 million, had not been paid back in full. And in fact, only a very small portion of it had been paid back. So for reasons I cannot fully discern or understand, the Bank of Baroda allowed Centaur Mining to close down the only asset that was giving Bank of Baroda security over really a truly vast amount of money. Once that money is then deposited into the fixed deposit accounts, once the fixed deposit accounts are closed, the amounts are then dissipated.
Sorry, Mr. Holden, you've just said something very, very significant, but can I just clarify that I got it correctly? That Bank of Baroda had granted the original loan to Tegeta against security of the 800 million plus fixed deposit of Centaur Mining.
That's correct, Chair.
But then on the 6th of April 2017, that's almost a year after the event, Bank of Baroda allowed Centaur to take this asset that had been pledged in their favor and to move the funds into its current account before Tegeta had repaid its loan. Is that correct?
That's correct, Chair. At the point at which that fixed deposit account is closed, only one payment had been made to the loan account of 242 million rand, that ultimately derived from payments from Eskom, leaving more than, well, I think roughly 2/3 of the original loan unpaid and effectively unsecured.
Okay, so be that as it may, 868 million makes its way into the Centaur current account. And what happens to it there?
Certainly, Chair, once it's paid into the Bank of Baroda current account, it is then paid over the course of a month into Centaur Mining Standard Bank account. From Centaur Mining Standard Bank account, which has received now 905 million rand, it transfers all of that 905 million rand into Centaur Ventures Bermuda account. And then it becomes increasingly complicated because as soon as those payments are made into Centaur Ventures Bermuda then immediately returns substantial portions of that amount, although not the entire amount, and I think that's important, to Optimum Coal. And I'll just highlight how that happens here on the diagram. You have here at this, where I'm circling, you have an amount of 905 million rand going to Centaur Ventures Bermuda account. And then running down here to the left, I have shown the funds moving from Centaur Ventures Bermuda account in 3 transfers.
Sorry, Mr. Holden, are you on page 327 now?
Let me double check. Yes. Once those amounts are then paid from Centaur Ventures, they are paid into Optimum Coal Mining's Bank of Baroda account, 02253. Portions of that amount is transferred from Optimum Coal's account into Tegeta Exploration and Resources Bank of Baroda account. We have a total amount transferred of 470 million rand. That's transferred from Optimum Coal to Tegeta Resources Exploration and Resources. And then those amounts are then transferred to Tegeta Exploration and Resources loan account to settle some of those loan facilities. At this stage in time, chronologically, that left an amount outstanding of 122,632,445 rand and 96 cents. To give a very high-level summary, what we effectively see is the fixed deposits are closed, the funds are paid to Centaur Ventures, immediately recycled back into Optimum Coal, and a portion of those recycled funds are then used to pay back to get to Exploration and Resources. The key element to this discussion is that it's not the entire fixed deposit amount or that gets paid back into the loan amount. It's only a portion of that amount. So realistically speaking, if you were to look at the total true cost of the purchase of Optimum, while Trillian fronted capital, sorry, not Trillian, Centaur fronted capital of 842 million rand, it actually, in real terms, only paid 470 million rand for the purchase of Optimum. And the rest is sourced from multiple sources, 2 sources in particular, one being Eskom and the second being Glencore.
And very briefly to describe the Eskom and Glencore payments.
Certainly, what we have, I need to go back, I'm afraid, in the diagram to page, very small on my, 326. And there's effectively 2 streams. There's 2 Eskom payments that are made to satisfy this portion of the diagram. First, on the 5th of April, you see two amounts transferred by Eskom. One is an amount that's paid to Koenfontein coal mine, which had formed part of the Optimum assets that to get to exploration and resource purchase. It's paid an amount of 168 million.
Mr. Holden. I'm sorry, Mr. Holden. Did you say 326? Did you say page 326?
326, Chair.
Because I'm trying to look at.
It's at the very bottom of the page,
Oh,
Chair.
okay. No, I was looking at the top. Okay, all right. Yes.
Thank you, Chair.
Okay, continue.
So on the 5th of April, Eskom transfers 168,241,108 rand and 28 cents to Koenfontein's coal mines Bank of Rhoda account. And immediately on the same day, of that amount of 168 million, Koenfontein coal mine transfers 162 million to Tegeta and Exploration Resources Bank of Rhoda current account. And then you follow the stream that goes up diagonally left from Eskom. Again, on the same day, it pays an amount of 81,048,290 rand and 26 cents. And it pays that to Optimum Coal's account at Bank of Rhoda 02253. And again, on the same day, that then funds a transfer of 80 million rand from Optimum Coal to Tegeta and Exploration and Resources. Those two amounts commingled then funds a repayment of 242,231,000 rand to Tegeta Exploration and Resources. So in very high level terms, you actually see the real cost borne in the purchase of Optimum in relation to the central stream, 242 million here derives from Eskom. There is then a second and final Eskom stream, which I'll need to locate very quickly.
Mr. Holden, are you not thinking of the Eskom payment in the Trillian stream?
I am. Apologies, Chair. I am getting the two confused. So these are the only Eskom payments that are used to settle the central loan. Apologies, Chair.
Maybe very briefly to take the Chair to the Eskom payment on the Trillian stream, which is at page 331.
Yes, I'm there.
Chair, as we can see here at the very bottom of the page, you have the Eskom entry, and to the left of that is Glencore International. And what this shows is that on the 16th of January 19, an amount of 67,578,027 rand and 59 cents is paid from Eskom into Optimum Coal's Bank of Rhoda current account 02253. It's joined there by a payment made the following day by Glencore International in an amount of 103,080,442 rand and 82 cents. Optimum Coal then draws on those two amounts to fund a payment of 130 million rand into Tegeta Exploration and Resources Bank of Rhoda account, which I'm circling here. And then finally, on the 17th of January 2017, over here, Tegeta Exploration and Resources uses that plus additional amounts that are residual in that account to pay 152,592,268 rand and 63 cents to Tegeta Exploration and Resources. I should point out, Chair, that I've adopted a more conservative accounting in terms of how much Eskom ultimately pays in relation to this amount. I've assumed that of the 130 million rand that's transferred, I've assigned the full 103 million rand to the Glencore payment and the amount outstanding to the Eskom payment, although it'd be equally true to say that it was that 130 million rand is made up of the Eskom 67 million rand deposit and the remainder of the Glencore deposit. But I think in an abundance of caution and to not overstate the case, I've opted for the lower figure from Eskom to satisfy the purchase, the payment.
Okay.
Can you take the chair through steps 9 and 10 to see what happens when Tegeta then uses these funds from Glencore and Eskom to pay off the loan that was secured against the Trillian fixed deposit, and the Trillian fixed deposit goes back to Trillian?
Certainly what you have here is, and I've just noticed this is a typo on this which needs to be corrected, I'm afraid. It reads the 18th of January 2016, it should read the 18th of January 2017. And that's the funds flow from the Bank of Baroda fixed deposit account to Trillian Management Consulting. But in any event, on the 18th of January 2017, 160,246,000 rand is transferred from the closed fixed deposit account into Trillian Management Consultants Bank of Baroda current account. On the same day, that amount is then transferred, and it's this wiggly line that goes up and around Waxman's and over to the left. Trillian Management Consulting then transfers an amount of 160,246,000, which is the exact same amount that's just been paid in from the fixed deposit account, into Central Mining's Standard Bank account. And again, on the same day, Central Mining then transfers exactly the same amount, 160,246,000, back into Central Ventures Bermuda account. And I think there's two implications here that need to be emphasized. The first is that very obviously at Eskom, covering the true and real cost of the purchase of Optimum to a certain value here. The second is that what this effectively does is it allows original funds that were originally sourced from a criminal source, which is Griffin Line, to re-enter the Gupta enterprise to be used at their discretion going forward.
Can I make a third observation? What you've described in relation to the Trillian stream is that funds that originally are stolen from the Transnet Second Defined Benefit Fund make their way through to Trillian, where a Trillian fixed deposit at Baroda is used to secure a loan in favor of Tegeta to purchase Optimum. And a year or so later, when that fixed deposit is released, the funds immediately flow back to Central Ventures in Bermuda. Is that correct?
That's correct, Chair. You effectively have funds stolen from pensioners to both provide capital so that the Gupta enterprise can buy Optimum, and then subsequently be effectively stolen and transferred into Central Ventures in Bermuda.
Very briefly I don't know if it is possible to do it briefly, but as briefly as possible to deal with what happens to the Albertine stream fixed deposit, and I think the starting point will be page 333.
Yes, I'm there. Yes, Mr. Holden.
In this regard, again, and this is actually particularly interesting because of the date, on the 20th of April 2016, Albertine closes its fixed deposit account. That's 6 days after it had been created and the loan had been issued. And and the proceeds are then paid back into Albert Times Bank of Baroda account. From there, then transfers amounts into 3 first-level laundry entities, Majul, Full-Time Consultants, and Bursa Projects, of which a certain amount, and I have the full amount to the right here, is transferred into what I call an intermediary laundry vehicle called the Samed Bullion Group, and in total, the funds that ultimately derive from Albertine, the total amounts are 9.5 million rand is paid into Samed Bullion by Majul, 3 million rand is paid by Full-Time, and Bursa Projects pays 8,714,178 rand. And that's all done between the 21st and the 26th of April. So if we move to the following slide. Which is page
334.
334, thank you. Of these amounts that are deposited into Samed Bullion's account, the funds are then transferred into an account by the name of Zokubite, which I did address briefly in the evidence I led on Tuesday. Zokubite is a feeder account that collects funds and then pays them onto onshore offshore bridges to move abroad. To the 22nd and 26th of April 2016, Zokubite transfers 3,536,970 rand and 6 cents to Vala Zone at Sasfin Bank, and Vala Zone is an onshore offshore bridge. And then if I zoom out very far, you can see that at the top of the page, Zokubite then transfers of that amount 245,416 rand
Dollars.
to Griffin.
Dollars,
Sorry,
not
$245,416 to Griffin Line in 6 payments between the 22nd of April and the 26th of April 2016. So again, in very high-level summary, we have funds, part of which is stolen from pensioners, another part from the Transnet Club loan, being used to provide the bridging capital to buy Optimum. And once that criminal end has been achieved, the funds are then moved through a complex local laundry, and eventually a portion of it is paid out to Griffin Line. And if we move to the following page, I don't want to overstay my welcome on this part of the evidence, and I will rely on the evidence leader to give me the page number.
335.
We can see a second amount transiting to Griffin Line, and the way that works is that of the funds paid to Samed Bullion Group by Majul, Full-Time, and Bursa, an amount of 4 million rand is transferred on the 21st of April 2016 to Shazari Trading, where it commingles with other amounts that have been paid in by Samed Bullion. Shazari Trading is a feeder account which collects and bulks funds from multiple different sources and then pays them onto an onshore offshore bridge. In this case, it makes a payment of 5,867,450 rand to Seattle Grain, of which 4,574,959 rand and 40 cents ultimately derives from the payment from Samed Bullion and therefore from Albertine. And then again, going to the very top of the page and following it round, on the 22nd of April 2016, Seattle then makes 2 transfers of $100,000 each, equal to $200,000, and that is paid to Griffin Line Trading, completing the step.
And would those 2 Griffin Line payments be the same payments that we discussed in your evidence on Tuesday, in the context of which you you pointed out to us that roundabouts this time there was a Gupta wedding taking place.
That is correct, Chair.
Very briefly, the last diagram that discusses the disposition offshore of the Albertine stream funds, that's on page 336.
Certainly, Chair, this is looks quite complicated, but I'll try and make it as simple as possible. Effectively, what you have is of the remaining amount that's been paid to Samed Bullion Group by Majul, Fortime and Bursa, 2.85 million rand, which is drawn from the second Majul payment, is paid to an entity by the name of Studio de Pablo. Studio de Pablo is a particularly active onshore-offshore bridge, and it then transfers on the 22nd of April 2016 an amount of $208,456 into the account of an entity by the name of Flybridge DMCC. Flybridge DMCC may ring a bell because it was the only account and the only company that received payments from Regiment Asia, Sequester Group and Morningstar by HSBC in Hong Kong. Of the remaining amount of these payments, between the 21st of April and the 26th of April 2016, 1.5 million rand is paid into an entity by the name of Zax Radio and TV, which I deal with at length in my report, and appears to be quite a key part of a large local laundromat. On the 25th of April, finally, to deal with the final stream, 1,050,000 rand is paid to the account of CMC Distributors. CMC Distributors is again a feeder account for an offshore bridge. That 1 million rand is commingled with other amounts to pay CCE Holdings on the same day of 3,748,585 rand, and then is transferred onto various Hong Kong and Chinese accounts that I believe are part of what I call the Hong Kong China Laundromat. I should make the point here, which I haven't raised already, but they are disclosed in my report. All of the onshore-offshore bridges that I've mentioned here, CCE Holdings, Vala Zone, and Seattle Grain, form the subject of extensive investigations by the Reserve Bank. And in each case, the Reserve Bank was able to secure a forfeiture of funds based on the fact that they had committed violations of the exchange controls regulations.
Just to tie up this section relating to the flow of funds on the optimum purchase, at page 338, you have a diagram where you depict the total Eskom contribution to the purchase. Can you take the chair through that?
Certainly, Chair. This is a very simplified version of what I've been describing in relation to the Eskom stream. At the very top, you have the entry for Eskom, and I'll zoom into it. And I've noted at the top, the effective Eskom contribution to the purchase of Optimum is 1,046,522,865 rand and 79 cents. And that's paid in 3 separate streams. The first stream is the stream on the left, going diagonally down. And those are amounts paid straight to get to exploration and resources. Those are amounts that are paid to finance purchase before the purchase takes place. Those happen on the 13th of April. The total amount transferred is 782,211,861 rand and 8 cents. The second stream is the Centaur stream, which I have then illustrate to reiterate. Eskom makes 2 payments, one to Quinfontein and one to Optimum Coal. Those payments are then used to transfer ultimately into the gettor's Bank of Baroda current account, and from there to pay the loan account 06467. I've highlighted these 2 payments here in red because that is the amount derived from Eskom that is ultimately paid back to settle those loans. And then the final stream runs to the right-hand side, and that's the Trillian stream, where Eskom pays an amount of 67,758,027 rand. The Optimum Coal, which funds the payment of 130 million rand to get resources, and that funds in part the repayment of the Bank of Baroda loan. And that effectively subsidizes the transfer of 160 million rand to Central Ventures. As I've mentioned earlier, I've assumed in the most conservative analysis that in this stream, Eskom contributed 22,311,004 rand and 71 cents.
Sorry, that at the top of that right-hand column, you say 103 million from unknown source. I understand you've subsequently been able to ascertain who that unknown source was.
That's correct, yes. So subsequent to this diagram, in which I asked the Commission to identify the source, and it was confirmed to be Glencore International.
And can you briefly explain to the Chair what this is the second Glencore payment that we've seen in this process. What are these payments for?
I'm afraid the evidence leader has called me out. I'm actually not too certain what they're for.
Well, we'll put up a document that shows that they were for the purchase of coal in terms of contracts that had been concluded with the business rescue practitioners before the Guptas took control of Optimum. Mr. Holden, that concludes our evidence in relation to the Optimum purchase. The last topic that I would like you to address is the more general issue of remedies and action that might be taken to try to avoid these sorts of events happening again in the future. And in that context, I'd like to ask you to go to the submission from Shadow World and Open Secrets that I think was Annexure H to your report, and unfortunately I've lost my reference for it, so I need I may need a short indulgence here.
I have it as Flow Funds 20, page 340.
Thank you very much. 340. Now we only have half an hour left. Maybe, I mean, the start of that submission deals with social harm caused by state capture and mechanisms that might be put in place to make it more difficult and to avert that social harm in the future. Can you very, very briefly give an outline there, and then maybe we can get into more detail in relation to very specific recommendations that you make in relation first to recovering some of this money, means in which some of this money might be recovered, and secondly, in relation to systems of sanctions that might ensure that corporations in particular are less likely to enter into these sorts of transactions in the future.
Certainly, Chair. I think my evidence leader wanted to add.
No, I'm happy for you to go.
Okay. Thank you, Chair. This report looks at two different themes, as it were, of anti-corruption enforcement post facto. And the first section looks at social harm caused by grand corruption and state capture. We've identified three, I think, pretty uncontroversial elements of social harm in relation to state capture. The first is that it erodes on the ability of the state to deliver on their constitutional obligations to better the lives of ordinary South Africans and deliver on their socioeconomic rights. A good example of that is the effective collapse, or certainly the significant deterioration of the services provided by PRASA. The second cost is the social cost of money being diverted from service delivery and other useful social expenditure to pay bribes to criminal enterprises. A good example here is the Transnet locomotive contracts, which had to include an increase in the price to facilitate a 20% or 21%, depending on the contract, bribe margin that was paid effectively to the Gupta enterprise. And as I show in my report, that equals about 7.8 billion rand lost to the state. That then has knock-on effects as the state has to then inject funds into SEOs at a time now of particular economic strain, and it leads to cuts in other areas. For example, the most recent budget reduced the budget for the MPA and it also reduced the budget for the SIU, which is clearly problematic. And then finally, the social harm that comes from the failure of the state to deliver services creates its own economic and social harm and has indirect effects, but it also may constrain businesses or entrepreneurs from investing in the economy for fear of corruption and state capture. Now, I think these are all very uncontroversial points. Where we think this discussion could go most fruitfully is that there are a number of international examples where social harm is considered specifically in relation to civil actions around compensation. And here, I'll point just to some very quick references. First is Article 34 of the United Nations Convention Against Corruption, which states that in accordance with the fundamental principles of its domestic law, states should address the consequences of corruption. And in this context, states parties may consider corruption a relevant factor in legal proceedings to annul or rescind a contract, withdraw a concession or similar instrument, and I think this is the emphasis here, or take any other remedial action. And we've seen this approach adopted in Costa Rica in a very interesting case, a very prominent and controversial corruption case that took place in Costa Rica. And what happened there was that upon the conclusion of the criminal investigation, the Attorney General brought a civil claim against the company that had paid the bribes. And that civil claim effectively enumerated the cost, the actual economic cost of that social harm to the state, and sought, I think it was over $100 million in relation to that specific cost. And the way they did that was to appoint an econometric expert to make an assessment of what the costs were, both in terms of the cost to average and ordinary citizens, and their quality of life and potential economic opportunities, but also what they saw as the knock-on effects in the degradation of citizens' belief in their own democracy, and how that led to them not engaging with the electoral process. And that process eventually led to a settlement, but I think it's a very interesting example. And one final point should be made in relation to that, is that UNCAC, which is the UN Convention Against Corruption, when acknowledging social harm, recognizes that it's a broad category of individuals and people who suffer harm that's beyond just the state and state institutions. And it recommends very clearly that, and I'll read the recommendation here because I think it's so important, while the convention does not provide a definition of who is a victim of corruption, it is important to adopt a broad and inclusive approach, recognizing that individuals, entities, and states can be considered victims of corruption. And furthermore, civil society and non-governmental organizations play an important role in ensuring that victims are represented in corruption proceedings, and as such, and I think this is the key point, should be able to report crimes give evidence, represent victims, or bring public interest litigation. And that brings us to the recommendations flowing from that section, which appear at page 346 of bundle 20.
Yes.
And here I'd like to emphasize the first two recommendations. Open secrets and shadow world investigations, we believe that the Law Commission should research collective social harm that results from state capture and other economic crime, and who can institute legal action, specifically to provide additional grants for legal standing when claiming damages or restitution on behalf of an SOE. And that's a recommendation we've made to the South African Law Commission. And then the second recommendation I'd like to highlight here is that we would recommend the Department of Justice and Constitutional Development develop reporting mechanisms for members of the public to participate in reporting and addressing state capture and other forms of grand corruption. And it should be brought in line with international best practice. That's the social harm aspect of this submission.
The next topic that you address in the submission is remedial action for to be taken by SARS under Section 23(0) of the Income Tax Act. And can I ask you first to explain what 23(0) of the Income Tax Act says?
Certainly, Chair. I'll read the relevant paragraph, if I may. Section 23(0) of the income tax reads as follows. Deductions, 23 is headlined that deductions not allowed in determination of taxable income. And it reads, no deduction shall in any case be made in respect of the following matters, namely, at subparagraph O, any expenditure incurred, subparagraph O1, where the payment of that expenditure or the agreement or offer to make that payment constitutes an activity contemplated in Chapter 2 of the Prevention and Combating of Corrupt Activities Act, 2004, at point Roman numeral 2, which constitutes a fine, charge, or a penalty imposed as a result of an unlawful activity carried out in the Republic or any other country, if that activity would be unlawful had it been carried out in the Republic. And then finally, at 3, any expenditure incurred constituting fruitless and wasteful expenditure as defined in Section 1 of the Public Finance Management Act, determined in accordance with that act. And in very broad summary, it means that taxpayers or both individuals and companies cannot claim as deductions any payments they make in fulfillment of corrupt activity.
And why is that? What are the implications of this, and what are you suggesting that SARS should be doing?
Certainly, I've been very interested and heartened by the action that SARS has taken in relation to regiments. And in that action, what has happened is that SARS has declared payments that regiments made to first-level laundry entities to be non-deductible, and regiments had actually deducted those amounts from their taxable income. And the potential for the state to recoup funds there is quite promising. And I would very, very strongly urge SARS to consider looking at all the evidence presented in my report, and in particular to approach those companies that paid any amount to first-level laundry entities to see if they deducted it from their taxable income, and to take the appropriate action. And to follow that stream of accountability, any entity that received payments from first-level laundry entities should also be subject to an investigation in that regard.
Can I ask you in that regard to go to page 434 of Bundle 20?
I am there, 434.
434. And can you identify that document to the Chair?
Certainly, Chair. This is a letter being sent from SARS to the Public Officer of Regiment's Capital, 35 Ferguson Road, Nalovo, and for the attention of Mr. Bernard Mofokeng. And what it sets out is a finalization of the audit. I should rather refer to it as a memorandum rather than a letter, but it indicates the finalization of an audit that SARS has undertaken into Regiment's Capital for the years 2014 and 2016.
Chair, I wonder if we could ask for this document also to be introduced as an exhibit.
Yes.
We're at VV10K.
So the letter from SARS addressed to regiments dated where is the 31 March 2021 is to be admitted as an exhibit and will be marked as exhibit. Did you say VV?
K.
VVK, that's WVK. Thank you.
And just very briefly to describe, I don't want you to take the Chair through this document, just describe what it is that this audit concludes in relation to issuing, recommending increased tax liability for Regiment's Capital. Sorry, Mr. Holden, I'm not sure if you heard my question.
Certainly, Chair.
Can you very briefly describe what this...
I did.
Thank you. Can you then answer the question?
I'll answer that demand. What the memorandum sets out in summary is that SARS has found that regiments made very large payments to first-level laundry entities, Homex, amongst others, and has found that those that regiments then deducted those payments from its taxable income as expenses. And SARS has now ruled that those cannot be deductible expenses, and on effectively two grounds. The first ground is that it constitutes corrupt activity under PRECA and therefore can't be deductible. And that
well, I guess you'll have to repeat that sentence, Mr. Holden. Sorry, Mr. Holden, I guess you'll have to go back maybe 3 sentences back because there was a technical glitch. We couldn't hear some of the things you said.
Apologies, Chair. The essence of the audit is that regiments were making payments to first-level laundry entities and declaring those payments as deductible expenses. SARS has now ruled they are definitely not deductible expenses. First, because they constitute violations of PRECA on their own terms, and second, because deductions could be where an actual service is being provided, and that has not been done in this instance.
We are not succeeding. I think one of the things I thought we could consider, Mr. Chaskalson, is that after Mr. Holden has finished, maybe the transcript could be made available to him as soon as possible so he could go through and pick up where there are inaudibles that make it difficult to follow what he's saying, and while everything is fresh in his mind, he could assist to fill up or fill in those gaps. What do you think of that?
If he would be willing to do that, I would
or if
strongly
there's
support
another
that.
way, if there's I'm just concerned that in the end, the transcript we have should be one where one can reasonably follow what he was saying.
Indeed.
So if there's another way, that's fine, as long as in the end that whatever gaps there may be which make it difficult to understand what he's saying can be fixed.
Between our team and Mr. Holden, we will
Yeah.
find a way of curing that problem. But
Yes.
for now, it would be, we're right at the end of his evidence. It would be good if we could find a way just to complete it.
Yeah, no, let's continue. Yes, Mr. Holden?
I'm not quite sure where I got cut off, but I'll state again what the SARS order found.
I think you had, I'm sorry, I think I had heard the first ground on which you said, SARS said those amounts were not deductible. I'm not sure that you had got to the second ground, but at least if you did, then I didn't hear that part.
Thank you, Chair. So as I said, the first ground is that they constituted violations under PRECA. The second ground is that deductions can only be made where legitimate services are provided, and none of these companies provided legitimate services.
Okay.
Now, can I ask you to go to table 113 of your report at Bundle 9, which is total payments to first-level laundry entities by state capture. It's where you itemize the origin and destination of the 1.2 billion odd that went to first-level laundry entities.
Could I get a page reference?
It is 194.
Certainly, I'm there.
Now, would the logic of the SARS audit letter in respect of regiments apply equally to every one of these cases that you list in table 113?
Absolutely, Chair.
Thus far, you've confined yourself to first-level laundry entities. Can I put another example to you? We heard on Tuesday that T-Systems made payments of over 300 million to Seshaba after being directed to do so by Salim Essa. Is that something that SARS, in your opinion, should be investigating in relation to see whether those payments were deducted from T-Systems' taxable income?
Absolutely, Chair.
And if you were to categorize more generally the examples like that T-Systems example that don't relate to payments directly to first-level laundry entities, how would you characterize them?
I would characterize them as payments made by state contractors to recipients who form part of the Gupta enterprise or intermediaries for the Gupta enterprise, where those payments were linked to the award or fulfillment of that contract.
Now, I haven't done my preparation, but I suspect that there is a table in your report which brings them all neatly together. If we can briefly go to your list of tables in your report and identify what table that would be. The list starts on page 12. And
the list. And are you looking for the total payments made by the state?
no, I'm looking at total payments made to the Gupta enterprise.
Did you say page 12?
Is where the list of tables starts. I'm just hoping to be able to identify the relevant table that we can ask SARS to look at.
That can't be bundle 9, eh? You have moved to another one?
It will be bundle 9, Chair.
Just that what I see at page 12 is a continuation of a list that started much earlier.
Indeed. I think it's at page, if we go to page 225, I think I found what will be our table.
At page page 225. That's where we find table 133.
No, it's, maybe I must abandon this project. I've got. There will be a table there. We can ask Mr. Holden just to identify that table after the event. Yes. But you're talking about payments that were made to Gupta identified, that were made by contractors with the state to subcontractors essentially placed there by the Gupta enterprise. Is that correct? I'm afraid our signal is dropping again.
That is correct, Chair.
Okay, it's back.
And I've fortunately found the reference that you are referring to. It's table 134.
And the page number for that?
Table 134 starts at 226. Although the relevant portion of that table is at page 228.
So it's from page 226. Sorry, it's from page 227 onwards.
At the very bottom of the page is. Yeah.
226 at the bottom.
And the section would be the section headed Payments by State Contractors Derived from State Capture Contracts at page 227, as opposed to direct payments to the Gupta enterprise.
That's correct. That's actually Flow Funds 9228.
Yes, FAF 9228. So it's payments by state contractors derived from state capture contracts. Yeah. The next issue that you deal with in terms of remedial action is debarment. Can you explain what you mean by debarment and what you are recommending in that regard?
Certainly, Chair. Debarment is a tool that allows the state to designate an individual company or supplier to have committed a violation of good practice with governance, usually a violation of PRECA or failure to deliver a contract, and then effectively ensure that the state issues no further contracts to that company for a specified period of time. What we found in our very long period of work in relation to anti-corruption enforcement around the world is that the issue that most alarms the shareholders of large corporations is not necessarily the payments of fines, which may become the cost of doing business in any event, but is the idea of losing potential future income. And a strong debarment regime is, I think, fundamental to creating a system where you don't have a repetition of state capture and corruption. And in this regard, I'm very pleased to see that the draft act, I'm trying to find the exact name, is the draft Public Procurement Act, actually envisages the creation of a centralized debarment process overseen by an independent regulator, which I think would be a really great step forward for South Africa. The one nuance I'd add to that is that I do believe that the draft Public Procurement Act should consider including some mechanism through which the regulator is empowered to create a proactive investigations unit that would proactively monitor procurement as they take place as a preventative tool. I fear that without that independent investigative mechanism, the regulator may not detect all of those payments. And of course, there's ways for that to be decided. For example, it could be that procurements over a certain value, say 10 million rand, would immediately trigger a compliance check and a monitoring process by the regulator. I think that would be a great addition to and a great intervention into ensuring good public procurement practice.
Can I ask you to go to page 524 of Bundle 20, because just so that we can identify the draft public procurement bill that you're talking to, page 524.
And there.
And is that the document that you're referring to when you talk about the Draft Public Procurement Act?
That is correct, Chair.
And Chair, can we admit it as an annexure?
Yes, that would be
VV10.L for lemon.
The draft public procurement bill will be admitted, which appears at page 524, will be admitted as Exhibit WV10L.
And just to clarify, if you go to page 543, section 22 of the draft bill, that is the proposed debarment regime in the draft bill. Are there any comments in relation to that proposed debarment regime that you would make to the Chair?
Certainly, I think, to reiterate, I think that debarment function would work best in those cases where the regulator has a proactive investigative function. And that could act as a brake on potentially pure procurement practices. I think it could make a very substantial difference to South Africa. I should mention that I think that two further recommendations should be considered. I think it should be, and I'd imagine it would be, the regulator should be empowered to create a publicly available database of all companies who've been placed under debarment or being investigated for debarment, because it does actually, the Act does allow for temporary suspension or temporary debarment, and the detailed reasons for that debarment and suspension. And I think in the case, that should obviously be publicly available to all citizens to be able to read and interrogate, but it'll also allow accounting officers to very easily investigate whether companies are added to that database. And this may be adding too many things to a wish list, but I do think there is some power in a state where it places a multinational company under debarment to alert the authorities in its home country that it has been placed under debarment, and whether they want to take similar action as well.
There's one issue that I don't see in this draft bill, which is that, as I read the draft bill, debarment consequences apply only to the entity itself that has been found to have contravened the various, or to being guilty, in inverted commas, of one of the various grounds of debarment, not to the individuals who control that entity or who are the beneficial owners of that entity. Is there any way in which this sort of issue is addressed elsewhere in the world of which you're aware?
In a lot of different procurement processes, and I'm referring here to the EU in particular, is that directors of companies have to indicate their past and previous directorships in any tender process, which will then allow the accounting officer in this case to identify whether they've been involved in any other company that has defrauded the state in some way. I could see very easily how it would be a very straightforward process for people to be debarred for their work on Company A, and then spend not very much money to form Company B to get around those debarment issues. And that should obviously be factored into the public procurement regulations, that it should also extend to directors, and that it should explicitly call for accounting officers to ascertain the history of the directors and their previous companies in relation to the Act.
I'm aware that we are running short of time, but we are literally maybe 5 or 10 minutes before the end. Chair.
We can continue.
Thank you very much, Chair. In the submission annexure VV10H, there is a discussion of the role of settlements and in civil and criminal claims and deferred prosecution agreements. Do you want briefly to, or can you briefly address the Chair on those submissions?
Certainly, Chair. The reason that we traverse those issues is partially because of our work in monitoring how settlements are used and abused throughout the world when it comes to anti-corruption enforcement. There is very much a very live discussion in the anti-corruption community about what settlements actually achieve. In the US, they have a regime called the Foreign Corrupt Practices Act regime, the FCPA, which is enforced quite aggressively, but it's enforced through what they call deferred prosecution agreements, which are effectively non-criminal settlements or an agreement to defer a prosecution and for the entity to pay a fine. And what we've seen is a lot of calls for a lot of countries to adopt a similar process because it's seen as a way of expediting anti-corruption procedures, and it's seen as a way of expediting the state recouping funds from corruption. But what we've actually seen in those jurisdictions, and I'm talking here to the experience in the US and increasingly the experience in the UK as well, is that those acts do not deter corruption at all. In fact, there's an incredibly high rate of recidivism for companies that are issued deferred prosecution agreements. Increasingly, it seems that companies, I'm talking here about very large multinational companies, may consider paying a bribe just the cost of doing business. And considering that the likelihood of detection for corruption is quite low in the international community, they may consider that good business. And that's doing the exact opposite of what you want to achieve. It also creates a system where you have effectively a two-tier justice system, where somebody who's arrested and prosecuted, faces far harsher sentences for shoplifting a loaf of bread than an executive who perpetrates a fraud of great scale against a country or an entire continent, potentially. And that is clearly not acceptable in natural justice. The two other features of DPAs that are very problematic is that, generally speaking, they will only include a limited disclosure of the offence and the information of the offence in the public domain, which may preclude other jurisdictions who are interested in that company from proceeding with their own criminal investigations. You almost never see the executives in those companies held to account in any possible way. They're never prosecuted, or where they are prosecuted is an extreme rarity. And it does seem to me that a very obvious deterrent to crime is if the executives of those companies who've been involved in state capture face real criminal consequences for their action. And then finally, the introduction of a DPA where it may allow the state to earn a certain amount of money, it doesn't create a criminal record. And that means that the debarment function, which I think is absolutely fundamental to challenging corruption, can no longer be used. So where the state may be compelled to consider the introduction of DPAs, we would very, very, very strongly argue against that. That is not to say, of course, that we don't think plea agreements could be useful, because plea agreements do accelerate the process of a corruption and can allow for the settlement of a potentially difficult corruption case more speedily and the recovery of funds. But the difference there is that a criminal plea agreement has judicial oversight, first of all, so a judge can decide whether it's fair. And it means that there is a fair exchange in the sense that a company or an individual may receive a lesser sentence in return for something else, which is usually full disclosure of all the information of the Act. And that could be fundamental to further prosecutions and also to helping international prosecutions as well. So we would strongly recommend, we think that plea agreements are potentially very useful means of pursuing corruption. We would argue very strongly against out-of-court settlements of any kind and deferred prosecution agreements.
And the last topic that you deal with in relation to fighting corruption is the need for more transparency. Can you very briefly describe to the Chair what you are proposing in that regard?
Certainly, Chair. I think the phrase used to be sunlight is the best disinfectant, but I've been informed that sunlight doesn't disinfect anything. Nevertheless, transparency is absolutely vital to tackling corruption in all its forms. And I think there's a number of key areas where the transparency, where I think South Africa should really join what is becoming a bit of a transparency revolution around the world. And I think there's a couple of sites where that could be implemented. I think one is with the Companies and Intellectual Properties Commission. As it stands right now, it costs South African citizens quite a lot of money to check for the existence of a company and who its directors are and what their ID numbers are. That is actually very unusual in the international experience, where it's generally free at the point of access for all citizens to check who directs the company. I also think that, and I would very strongly argue that that should become a freely available public database. And obviously there can be discussions about how the income that CIPC might lose from that could be offset. But I think the gain to transparency would be absolutely enormous. The second thing that myself and a lot of other investigators and investigative journalists have really struggled with is the issue of finding out the beneficial ownership of companies. It's now very common around the world that all companies have to declare their beneficial owner. And I think that should become part of the CIPC's disclosure regime. It's not just directors who may be nominally directors in any event, but it should be established who actually owns the company or what other companies or trust companies own that company. And then the last recommendation on my wish list, and I know I'm going through a lot of big asks here, but as it currently stands, there is a real problem trying to establish the shareholding in a company if you're a member of the public. As it stands under the Companies Act, the share registers of the company reside with the company auditors. And in my experience, I've tried, I don't know how many times, to write to company auditors or to the companies themselves and say, under the Companies Act, you need to supply us on request with these share registers, and they are never delivered. And actually, this is quite a strange way of organizing things, because in multiple other jurisdictions, in fact, all of the jurisdictions that I was accessing records in compilation of this report, the share registers are submitted to the registry of companies. So I would recommend that the share registers, or at least an annual return setting up the ownership, is submitted instead to the CIPC on a routine basis, and that citizens should be allowed to access that information either by paying to download an annual return or potentially free at the point of use. I think that would make an absolutely huge difference to understanding, identifying the real owners and the real movers behind special purpose vehicles that are used throughout corruption schemes. I think it would be incredibly important to do that.
And finally, transparency in relation to public contracts and decision-making processes is an issue you address.
Certainly, there is, and I know that I'm hesitant to use NGO anti-corruption jargon speak here, but there is an open contracting revolution that's happening in many places, where as standard, huge amounts of information are made for free available to the public about contracting. And that information runs from the issuance of tenders to the award of tenders. So if I was to use an example, the European Union has a system called TED, or Tenders Electronic Daily. Every single tender or award that is issued by a state anywhere in the EU, full information is put online of that tender. So the tender award is publicized by there, and you can download it and it's there forever. The tender award is also announced, and that's very important because what is disclosed in that tender award are things like who the winning bidder is, what the total amount they paid was, how many other people were bidding for this contract, if it was a single bid contract, why was it a single bid contract, what is envisaged under that contract, whether, and I think this is really key here, whether that contract allows the primary contractor to use any subcontractors and how much will they eventually spend on subcontractors. And we've seen in relation to the Gupta enterprise that was a common theme of how they procured state capture in the Free State in particular, was to effectively act as bogus subcontractors on contracts to the state. And it also includes a very useful breakdown of the rationale behind the award. And that includes describing the scoring criteria and how those scoring criteria were reached, and also provides the actual scores that were given to different bidders under those different subdomains. Obviously, there's a degree of limitation of what's disclosed under commercial confidentiality, but a common thing that is done there is to not only list the number of tenderers, but to indicate the highest and lowest value offered by different service providers in relation to their contract. You can see if there's a big discrepancy between the amount that's actually awarded and the lowest possible bid. Now, I don't believe that those are not always going to be silver bullets in fighting corruption. But I do think having a system like that in place, and I understand there would be technical issues there, and it'd be an achievement to get it running, but I think it would massively improve the ability of the state itself, of companies and people doing business and ordinary citizens to understand how their taxpayer money is spent and to use those documents to ensure that corruption is caught. I think to myself, how much earlier would the Estina Frida dairy scandal have been caught if if the procurement process and the tender documents and the contract award were placed on a publicly available website? I think it would have been detected far earlier, and it would have stopped the frivolous theft of vast amounts of money from some of the poorest people in the country. And I think that sort of level of transparency could make a huge and fundamental difference to the health of South Africa's democracy.
Mr. Holden, is there anything else that you would like to address the chair on at this point?
At this point, Chair, I was going to raise a potentially very controversial point, which I have now decided not to pursue because I fear I might become the least popular person in South Africa. I'll put it out there for discussion, if I may, rather than making a recommendation, is that in certain countries around the world, and Norway is a very good example, there is a system whereby every single individual and every company in the country's tax returns, or a summary of those tax returns, are made available publicly on a database. So every citizen in the country can check what their prime minister or their minister of foreign affairs or whatever official they want to, and can actually even check their neighbor if they want to, what the total amount of taxable income was and how much they actually paid in tax. It's a very brief summary. But there have been a number of different surveys and investigations into that system in Norway, which has shown that massively increases the trust of citizens in their public officials. But it also detects income that can't really be justified. It's almost like a thumbnail lifestyle audit. I'm not going to say I recommend that be introduced into South Africa, but I think it would be an interesting thing for the Commission to consider that, and for the broader public to maybe discuss the pros and cons of a system like that, and how it could improve transparency in South Africa.
Okay.
Mr. Holden, you've given us some extraordinary testimony over a period of several months. Thank you very much for that. is there anything that we have missed that you would want to say as a last, as a sort of parting shot, or can we finally say goodbye and thank you?
If I may, I'd like to beg the indulgence of the chair, if I may. While I was preparing this evidence, my father died very unexpectedly and very suddenly in South Africa. He died at the age of 68. And because of COVID, I have not been able to go back and pay my last respect. I know he was very excited about my evidence before the Zondo Commission and very proud. And to the extent that this evidence is useful to the Commission, I'd like to dedicate it in his name.
Thank you very much, Mr. Holden. Our condolences about the passing on of your father. And you mentioned that he passed on while you were engaged in this process of assisting the Commission, and that he was proud of your role in that regard. I just want to take this opportunity to thank you for the evidence you have given. Quite clearly, there was a lot of investigation and research that has gone into all of this. I really thank you. Your evidence is very enlightening, and certainly it helps South Africans to understand a very important part of what was happening with regard to their money that was used in certain transactions in a way, to say the least, that is questionable. Thank you very much. We really appreciate it. I accept that this might be the last time that you appear to give evidence, but I suspect that we are still going to need you to interact with the Commission for quite some time in regard to matters that you have covered. Thank you very much, and once again, our condolences to you and your family. Thank you, Mr. Holden.
Thank you, Chair. Thank you very much.
Thank you. You are now excused. Thank you. Mr. Chaskalson, it's obvious that you and your team worked extremely hard in regard to bringing before the Commission, before me, this evidence. So I think your team has worked very hard over 2 years or even more.
Yes, I mean, the team was there before I came. They've been at it from the very beginning, Chair.
Yes, from over the whole period of the Commission. Thank you very much. We are going to adjourn now, and after lunch I will have counsel appearing for various NP officials who will appear before me and deal with give summaries of their versions in response to the evidence of certain witnesses. But I would like to see you before you go in chambers, Mr. Chaskalson. But otherwise, we adjourn.
Thank you, Chair.